Hello, welcome to week 2 of criminal law. This week we are going to be looking at 3 chapters. The first chapter is chapter 5, which deals with legality. And legality is based upon constitutional principles, which we will look at in a little bit. What does legality mean? Legality means that a person cannot be punished unless his or her conduct is defined as criminal under a then existing statute, meaning that there must be a statute in place which defines someone's conduct as criminal before that person can be punished. There is a prohibition against applying criminal statutes retroactively, and that is very important to know. Let's see if I can give you an example of this. Some of you might remember a case in North Georgia in the early 2000s about the Tri-State Crematorium case where a defendant, Brent Marsh, owned a crematory, and he was not properly cremating the remains of deceased people, and he was giving back to their relatives ashes that weren't really of the person who had died. Well, at the time, the state of Georgia did not have a specific statute in place which dealt with abuse of a corpse, and so Mr. Marsh had to be charged with fraud. Now, of course, that has changed, and I'm sure that Georgia has modified their laws, but at the time they could not proceed with the abuse of corpse charges, and they had to prosecute him for fraud, not returning the proper remains of the deceased individuals to their family members. So that is an example of when you might see legality. What are the reasons that laws cannot be applied retroactively? First of all, you want to prevent arbitrary and vindictive laws. You do not want to be in a country where someone sees your actions and they might not agree with it, and a lawmaker in turn creates a law that says that your actions are criminal, although there was no law in existence at the time you did those actions which said that your actions were criminal. So you want to prevent arbitrary and vindictive use of laws. Secondly, you want to enhance individual autonomy by maximizing the opportunity of individuals to follow his or her needs. Third, you want to provide fair notice, and that is probably the most important reason for legality, this whole fair notice, and you'll constantly hear about notice requirements under the Constitution. So provide fair notice of conduct or behavior that's criminal. This allows individuals or people the opportunity to conform their conduct to the law. Let's look at some constitutional considerations for legality. First of all, with respect to legislation, which is statutory law, there's a term called Bill of Attainder, and Bill of Attainder is special legislation that declares a person to be guilty of a crime and subject to punishment without trial. Pursuant to Article 1, Section 9 and 10 of the United States Constitution, that prohibits federal and state legislatures from enacting Bill of Attainders, or what's also known as ex post facto laws. Ex post facto laws are laws after the fact. With respect to the judiciary, because as you know, there are multiple branches of government, 3 branches of government. You've got the legislative branch of government, and you've got the judiciary. Under the judiciary or the courts, legality is applied to the court system or the judicial branch of government through the Due Process Clause of the 5th and 14th Amendments. This means that the courts cannot make ex post facto laws either, laws after the fact, and that is pursuant to the 4th and 15th Amendments of the U.S. Constitution. Another concept under legality is statutory clarity. criminal laws must provide a person of ordinary intelligence with fair notice of what is prohibited. Vague statutes, which means statutes that are unclear or difficult to interpret, are not permissible because this could encourage arbitrary and discriminatory enforcement by police officers and prosecutors. And our whole country, the United States, was founded upon this whole concept of legality. The reason for statutory clarity is to promote fairness. Moving along, when a criminal statute is clear and unambiguous, the courts must give the statute its plain and ordinary meaning. So the courts are going to interpret clear statutes or well-written statutes pursuant to their plain and ordinary meaning. When a statute, though, is unclear and ambiguous, the court's primary function is to ascertain the intent of the legislature. When a criminal statute is subject to conflicting reasonable interpretations, the statute should be interpreted in favor of the defendant. This promotes the whole legality concept that this chapter is talking about. And if you guys have ever read or looked at statutes before, you will see that some statutes are much better written than other statutes. Some statutes are very unclear and very difficult to understand, and like this slide shows, is that whenever the statute is ambiguous or it's subject to multiple interpretations, it is the court's primary function to ascertain the intent of the legislature. And when they're unable to do that because there's conflicting multiple interpretations of the statute's going to be interpreted in favor of the defendant instead of the prosecutor. Now, with respect to the Model Penal Code, which we've already discussed in our first class, states are not required to follow the Model Penal Code, but a lot of states have adopted some or many code sections and statutory sections based upon the Model Penal Code. But under the Model Penal Code, this requires criminal statutes to be construed according to their, quote, fair import, and that ambiguities shall be resolved in a manner that furthers the general purpose of the code and special purposes of a particular provision involved. So with, if you do read case law in criminal matters or case law in other matters, you will oftentimes see where courts are discussing how they're interpreting and applying statutes. So that is chapter 5, was it, I believe? And chapter 5, like I said, is going to be based upon the U.S. Constitution, the whole legality principle and fairness, and you want to provide notice to defendants. Okay, so moving along to chapter 7. Chapter 7 deals with burdens of proof, and we did skip chapter 6, which deals with proportionality. Burdens of proof. The prosecutor has the burden of production regarding all elements of a crime charge. And in this chapter, you will see reference to burden of production and burden of persuasion, and they are a little bit different. So let's look at the example on page 66 with regard to the prosecutor's burden of production regarding all elements of the crime charged. And you'll see when we get into different specific crimes that crimes will have multiple elements to it, and you can oftentimes break down the definition of a crime into multiple elements. So the prosecutor has the burden of production for all elements of a charged crime. So looking about a third of the way down on page 66, for example, assume that murder is defined by statute as the killing of a human being by another human being with malice, aforethought. For current purposes, this definition may be divided into 4 elements. Number 1, a killing. Number 2, of a human being. Number 3, of another human being. Number 4, by malice, aforethought. The prosecutor has the burden of producing evidence at trial regarding each of these elements. That is, she must introduce evidence that a life was taken, that the victim was a human being, that the killer was the defendant, which is the third element, and that the killing occurred with the mental state described by the law as malice, aforethought. That's the fourth element. Unless the prosecutor introduces sufficient evidence regarding each of these 4 elements, then she has not met her burden of production. And keep in mind, in a criminal matter, a defendant does not have to testify. So the defendant does not have to get on the stand, and they do not have to prove that they're not guilty. They can solely force the prosecutor to prove that they are guilty beyond a reasonable doubt. And we're going to look at that definition in just a minute. So do keep that in mind. Defendants are not required to testify, and they can simply force the prosecutor to meet his or her burden of proof beyond a reasonable doubt with respect to every element. But certainly the defendant does have the right to testify in a criminal matter if they so choose. The defendant only has the burden of production if he or she is asserting an affirmative defense. And we're going to look at affirmative defenses on down. Affirmative defenses, examples, insanity, self-defense, defense of others. We're going to look at some affirmative defenses in other weeks. The burden of proof in a criminal matter is beyond a reasonable doubt. This is the highest level of proof there is. You'll hear in the law, you'll hear reference to preponderance of the evidence. You'll hear reference to clear and convincing evidence as a burden of proof, and you'll also hear reference to beyond a reasonable doubt. Well, in a criminal matter, it is the burden of proof is beyond a reasonable doubt, which means the jurors must reach a subjective belief of near certitude of guilt. They have to believe that the defendant committed the crime, and the likelihood that the defendant did it was 99%. In a civil matter, the burden of proof might be preponderance of the evidence, and preponderance of the evidence means more likely than not or greater than 50%. And so in a criminal matter, the burden of proof is beyond a reasonable doubt, 99%. Failure to meet the burden of proof. The defendant can move for or request a directed verdict of acquittal if the prosecutor does not meet the burden of proof. And the judge, not the jury, makes the decision as to whether or not the prosecutor met the burden of proof beyond a reasonable doubt. And I guess I should have said this earlier or in another class, and I just happened to think about it right now. The prosecutor, when I'm referring to the prosecutor this semester, I'm referring to the state, or I'm referring in a federal matter to the government. They're the prosecutor, and they're the attorney on behalf of the state or the federal government who is pursuing the criminal charges of action in court. The defendant is the person who has the criminal charges pending against them. Now, moving on to burden of persuasion. Once the prosecution satisfies the burden of proof, the prosecution must persuade the fact finder beyond a reasonable doubt that the defendant is guilty. So the prosecutor has, first, they have to present enough proof that through their burden of production that the defendant is guilty beyond a reasonable doubt. And then secondly, they have to persuade the fact finder, who is the judge or the jury, beyond a reasonable doubt that the defendant is guilty. And like I said, a person is presumed innocent unless and until proven guilty pursuant to the Due Process Clause of the U.S. Constitution. What about burdens of proof with respect to affirmative defenses? If there is a recognized affirmative defense that is asserted by the defendant, such as insanity, self-defense, defense of others, we'll look at some later. Some states require the defendant to prove the affirmative defense by a preponderance of the evidence. That's only some states. Like I said earlier, the defendant does not have any sort of burden of proof if they're simply relying upon the prosecutor to prove the defendant's guilt. However, if the defendant is asserting an affirmative defense, if the defendant's saying, well, yeah, I committed the crime, however, I did it in self-defense, or yeah, I committed the crime, however, I was insane. Well, if the defendant is asserting that affirmative defense, they have to prove it by a preponderance of the evidence. A preponderance of the evidence is greater than 50%. Or more likely than not. That is a much lower threshold than the 99% beyond a reasonable doubt that the prosecutor has to prove for proving the defendant's guilt. So preponderance of the evidence, more likely than not, greater than 50%. This is applied in some states with respect to the defendant's burden if the defendant asserts an affirmative defense. However, some states require that the government or the prosecutor disprove some or all defenses beyond a reasonable doubt standard. And that's the minority of states. Not the majority of states are going to require the defendant to prove an affirmative defense by preponderance of the evidence. Now, what does the Model Penal Code say about the burden of production? It says that the prosecutor has the burden of production regarding each element of the offense. With respect to affirmative defenses, the prosecutor is not required to disprove an affirmative defense unless there is evidence supporting such defense. The Model Penal Code does not specify the strength of the evidence required to satisfy the defendant's burden of proof regarding affirmative defenses. Instead, the Model Penal Code allows courts to determine the strength of the evidence, i.e., how much evidence is required in order for a defendant to be successful in asserting an affirmative defense. So, like I said a little bit earlier, affirmative defenses, you're saying, yeah, I did what I have been accused of doing. However, I have a defense as to why I did that. I have a defense as to why, based upon my lack of mental capacity or self-defense, and we'll get into that later on. What does the Model Penal Code say with respect to the burden of persuasion? And I'm sorry, but this, I just noticed that this slide should say at the top burden of persuasion. So slide 13, it should say Model Penal Code burden of persuasion. The prosecutor has the burden of persuasion regarding each element of the offense beyond a reasonable doubt. That same 99% standard, almost certitude. The Model Penal Code allows the prosecution the duty to disprove defenses. I'm sorry, let me rephrase that. The Model Penal Code allocates the prosecution the duty to disprove defenses, assuming that the defendant has satisfied his or her burden of production. This does not apply to defenses in which the Model Penal Code expressly requires the defendant to prove by a preponderance of the evidence. So if there are any defenses, like I said, we'll look at the defenses more specifically, such as insanity, self-defense, defense of others. We'll look at those more specifically. But if the Model Penal Code says that the defendant must prove that defense by a preponderance of the evidence, then that's the case. That's what happens. However, if the model penal code does not give that defendant that burden of proof, then the model penal code at that point allocates to the prosecution the duty to disprove defenses, assuming that the defendant has satisfied their burden of production. All right, moving along to Chapter 8, Presumptions. In presumptions, it doesn't matter if you're in criminal law or civil law, and civil law is pretty much any area of law that's not criminal. It doesn't matter what area of law you are in, you are going to hear judges and courts refer to presumptions a lot. What is a permissive presumption? A permissive presumption allows but does not require the finder of fact to infer the fact which is an element of a crime from the basic fact that has already been proven. Example, the jury is instructed that it may but not need to presume fact B upon proof of fact A. So in that example, if a party proves fact A, then the jury is instructed that it may but it not need to presume fact B because fact A was proven. Permissive presumption is often referred to as an inference. Let's look at the example on page 79. This is about halfway down page 79. For example, a New Jersey homicide statute that in the prosecution of a driver for recklessly causing a death in his automobile, proof that the defendant was operating a handheld wireless telephone while driving a motor vehicle may give rise to an inference that the defendant was driving recklessly. Here, the jury may infer fact B, which is recklessness, from proof of fact A, which is operating a cell phone while driving, if the jury chooses to cross the inferential bridge from fact A to fact B, but it need not do so. So whenever you see that word may in there, that suggests the permissive presumption. What is a mandatory presumption? Mandatory presumption instructs the jury to infer a presumed fact if the prosecutor proves certain other facts. Example, the jury is instructed that it must presume fact B upon proof of fact A. And so and I meant to, on this slide, it should have said, see example on page 79. I wanted to refer back to that example that I just read about the New Jersey homicide statute. Assume that that statute said the New Jersey homicide statute provides that in the prosecution of a driver for recklessly causing the death of his automobile, proof that the defendant was operating a handheld wireless telephone while driving a motor vehicle must give rise to an inference that the defendant was driving recklessly. So if that statute had said must instead of may, then that would have been a mandatory presumption. It would have meant that the jury would be instructed to presumed fact B, which is recklessness, upon proof of fact A, which is that the defendant was operating a cell phone while driving a vehicle. So the statutory construction is so important. It's important to determine whether or not the statute says may or must, because one of them is permissive, which allows the jury to make an inference, and the other one, the must, is mandatory, which instructs the jury that they must presume fact B, in that example, recklessness, upon proof of fact A, that the defendant was using a handheld or using a cell phone while driving. What about mandatory presumptions, rebuttable presumptions? Rebuttable presumptions requires a finding of presumed fact upon proof of the basic fact, unless that finding is rebutted by the other side. This just means that that a presumed fact can be rebutted by the opposing side. So if the jury's instructed to presume a fact, under a rebuttable presumption, the other side can introduce evidence to rebut that presumption. Again, even if there is a rebuttable presumption, that presumption can never shift the burden of proof to the defendant. The prosecutor must still prove guilt beyond a reasonable doubt. So rebuttable presumptions can be rebutted if the other side submits sufficient proof to rebut the presumption. What about an irrebuttable or a conclusive presumption? You oftentimes don't see these in the law, but an irrebuttable presumption or conclusive presumption requires the jury to find a presumed fact upon proof of a basic fact, even if the opposing party introduces rebutting evidence. These presumptions are very, very, very rare in criminal law, and you just won't see them often. What about the Model Penal Code? What does it say about presumptions? The Model Penal Code does not recognize mandatory presumptions. However, the Model Penal Code, and that should be MPC, permits permissive presumptions or inferences regarding elements of a criminal defense. So it does permit permissive presumptions or inferences regarding elements of a criminal defense, but it does not recognize mandatory presumptions. All right, that is all I have for these chapters. I do have a discussion question that I want you guys to answer. And what you'll need to do is you're going to need to familiarize yourself with the County Court of Ulster County versus Allen case. This is on page 80, and I'm not going to make you read the full case online. It's a United States Supreme Court case. It started out, of course, like all cases do, at the trial level, and then it was appealed to the Court of Appeals and then to the United States Supreme Court. And the book talks about what the U.S. Supreme Court did on page 80 of that on page 80 of your book. So I want you to take a look at that, and then I've posed a hypothetical that I want you to respond to based upon that case. All right, that's all I have this week. Thank you all very much. Let me know if you have any questions.